Good evening, everyone. My name is and this is Bruce Collins, the Queen's Counsel, an expert in international arbitration, and a member of numerous arbitration panels throughout the world. Today, his lecture will be devoted to current challenges affecting international arbitration, and we all welcome you today at HSC. Thank you for coming.
My pleasure. Very well. What I want to talk about today will depend a little bit upon where you all are in your courses. Have any of you done international commercial arbitration yet, or are you about to start? This one should, yes, that's good. Has anybody started international commercial arbitration in their law course yet? Okay, so what on earth are the rest of you doing here? Is it because you think you might like to study international commercial arbitration? Yeah, that's good. It is a very, very exciting time for international arbitration because as the world trading system becomes busier and busier and busier, those trading partners who want to enter into a trading contract of some kind with their partners are quite often wary of doing so when the company with whom they're trading comes from a country which is not well developed and which does not have a legal system in which they can be confident. But has anybody got any idea why you would want to choose arbitration if you were selling goods into another country? Why not just allow things to be resolved in the state or national courts if there is a dispute under the international contract? Why arbitrate, do you think? Well, yes, what do you think, Vadim?
Well, one of the reasons is that arbitration can provide you with an impartial tribunal. And when you resolve your dispute in a national court, there might be a risk that this court will be more favorable to one of the parties to the dispute.
Well, that would never happen in Russia, of course. We wouldn't be worried about that here. But that's part of the answer, and thank you for that, Vadim. One of the key factors which was revealed in the Queen Mary and William University study in London to explain the reason why people preferred to arbitrate rather than litigate in the national courts was because arbitration was confidential, and almost 80% of the users of international arbitration expressed that as one of their most important reasons. The next most important reason, if not the most important reason, was an almost silent revolution which occurred in 1958 when a number of countries signed on to and ratified what was called the New York Convention. The New York Convention on the recognition and enforceability of foreign awards. Now, as you all know, if you have a judgment in one particular country, it is very, very difficult to enforce that judgment in another country. Sometimes it's impossible, sometimes it's extremely difficult. Now, what the New York Convention did, so far as the signatories to the convention were concerned, and there's now about 170 countries that have signed up, including Russia, which is of great importance. What it did, it was to say that if you had an international arbitral proceeding against an international party, and if you were successful, pardon me, in those proceedings, you could take the award that's in your favour and you could go to another country which is a party to the New York Convention, And you could go into court with that award and you could ask the court to, as it were, translate or transpose or change or substitute that award for a judgment of the Supreme Court of that state or country. Okay, so you started off with, let's suppose that Vadim's company has a claim against my company. Let's pick Mongolia, because Mongolia is a New York Convention signatory. He wins against my company. Now, without him doing any more, he's not going to get a judgment of any money against my company. But if he finds out that I've got assets in Australia, because Australia is a signatory to the New York Convention, he can take that award into a Supreme Court, let's say in Sydney, and ask the judge to give that award the effect of a judgment of the Supreme Court of that state. Suppose it's New South Wales. And then he can give, pardon me, the judgment to the enforcement authorities, the sheriff, as we call him from the Old English word, and he can take the enforcement proceedings against me by levying what's called execution against my property. If I have no property, or my company has none in Australia, but as I said the other night here in another lecture, the winning party discovers that I own a very expensive, valuable beach house in France, they could decide to take the award from Mongolia to France, because France is also a signatory to the New York Convention, and then they could execute against the property that my company owns in France. So this is one of the greatest features of private international law, and I was not joking when I said that it was really a revolution when we discovered that we could do that. Now that gives everybody the confidence that when they do succeed in an international arbitration, they can rely upon the New York Convention. Now, as well as what Vadim said about the reasons for arbitrating, his point was a very good one. You can get a very good international tribunal, but of course you can select that tribunal yourself. And so let's suppose that the arbitration clause provides for 3 arbitrators. Now, one party can appoint one, the other party can appoint one, and then those 2 party-appointed arbitrators will appoint the chairman. Now, although the arbitrators who have been appointed by the parties are sometimes called correctly party-appointed arbitrators, they owe their primary duty to the arbitration itself. They do not owe a duty to the party appointing them. And although within arbitration circles you will hear people talk about my arbitrator, that's really a misnomer. It's an incorrect use of language. The arbitrator who is appointed by a party owes a duty of integrity to the arbitration and to the result, not to the party appointing him. Now, that's a quick reference to the New York Convention. We're going to come back to that in terms of the Yukos case and in terms of Mr. Maximov's case. I think you're doing Maximov tomorrow, aren't you? The whole idea of arbitration, and the one word that you need to remember and then apply, is consent. International arbitration is a process which is a pure alternative to actions in the state court and in the national courts. And the reasons why you want to do that are, as I've set out earlier. As well as the word consent, you need to remember party autonomy. The parties run the arbitration to a point. The arbitrators have ultimate control over how the arbitration is conducted, but the parties have choices about all sorts of things. The most important choice they express is the one that is contained in the arbitration clause. And if you get this wrong, then it can be a disaster. Perhaps the simplest clause, and I've picked this largely because I've been on the International Court of Arbitration for the last 6 years in Paris, is probably the ICC model clause. But there are all sorts of arbitration clauses. But this is the building block upon which the whole thing rests. This one's a very simple one. The parties have agreed that all disputes arising out of or in connection with the present contract. So you've got a contract entered into by two trading parties, and in the arbitration clause, this is the central plank in what they agree. All disputes arising out of or in connection with the present contract. So that's a very broad clause. There have been all sorts of discussions over the years about the expression arising out of or in connection with or relating to or arising under. But since the famous English decision a few years ago now in Fiona Trust, Fiona Trust, a decision of the House of Lords in London, any arbitration clause which can be seen to express a general desire to go to arbitration will be favoured by the courts. The old days when arbitration clauses were struck down because there were finely reasoned arguments about whether something arose out of or related to, they're all gone. Fiona Trust says, if the court thinks the parties intended to arbitrate their disputes, then that's it. We're not going to go into the language of the clause. And this is a clause, this ICC clause, that has been upheld on many, many thousands of occasions. But let me read the rest of it, because there are other important elements in the clause before we get any further. Any dispute, etc., arising out of shall be finally settled. Now the key word there is finally, because what that means is that there will be no disputes heard in the state or federal courts. They've been taken out of those courts and put exclusively into the arbitration tribunal, the arbitral tribunal. And indeed, if you are a party to a clause of this kind, to subvent or to circumvent the clause and go to court, then the party who wants to proceed in accordance with the arbitration clause will be entitled to go to court and get what's called an anti-suit injunction. It sounds curious, but you can get an injunction from the court to prevent the other party from going to the court and forcing them to go to arbitration. Why? Because that's what they have agreed to do. Now, 100 or 200 years ago, the courts did not like arbitration, and they did not like arbitration clauses. They had the rather unusual view that they were going to be losing a lot of their work and therefore their power. But now, the wheel has turned full circle, and you have now courts which are very pro-arbitration. And the Russian courts are becoming more and more pro-arbitration. It's now easier to enforce a judgment in Russia than it was some years ago, for example. But we'll look at some of the curiosities of that in a moment. So that's the second feature. Any dispute shall be referred to arbitration where it will be finally settled. Now, the implications of the word finally are considerable. By that I mean that once an arbitral tribunal has brought down or delivered an award, the opportunities, the avenues by which you can challenge that award are very, very narrow. And the word finally, as it appears in the arbitration clause, means just that. And whilst for those who are just coming to arbitration, it does sound a little counterintuitive. But even if you can prove that an arbitrator or a tribunal has made a serious error of either fact or law, that alone does not entitle you to set the award aside. So the implications of the word finally are terribly, terribly important. And the sources of the power to set an arbitral award aside are to be found in, and we'll come to this in some detail because it's a crucial principle, are to be found in what's called the law of the seat, S-E-A-T, and in the 5 grounds in the New York Convention. Now, in the UCOS case, the award which had been handed down by a very, very strong tribunal was set aside here in the arbitrage court in Russia, and thereafter there were lots of disputes about this question, namely, what can you do, if anything, with an award that's in your favour but has been set aside at what's called the law of the seat? Now, in the arbitration clause, there are, as we've seen, 2 crucial things. One, the reference and the description of the disputes. 2, that they shall be finally settled. But in addition to those choices, the parties are given in the arbitration clause another very significant choice. They can pick what's called the law of the seat. Now, the law of the seat is the equivalent of saying, what is your procedural law going to be? What law of procedure will govern this arbitration? We'll come back to that. But just keep that in the front of your mind when you think about the 4th important choice that has to be made in the arbitration clause. And that is the law under which the dispute will be resolved. If it's an international trading contract and Russia is a party to that contract, or a Russian company, if that Russian company has enough leverage, bargaining power, that company may succeed in convincing the other party, who might, for example, come from a smaller and therefore less influential country. The Russian company might say to the Estonian company, the law of the seat is not only going to be Moscow, but the substantive law, the choice of law, will be Russian law. Okay? So you've got a choice of the law by which the contractual dispute will be resolved, and you've got a choice of the law which is going to govern procedural law. Now, Russia has signed on to the New York Convention, as I mentioned, and it is also signed on to the model law. And the model law, I think, particularly those of you who are about to start the arbitration course, is an extremely good way to learn about some of the familiar features of procedure in this area. But let me just remind you of what happened in UCOS, because UCOS is providing all of us with a textbook analysis of the New York Convention and what happens to an award which has been delivered in, say, my company's favour, and is then set aside at the seat, because that's what's happened. There was a ruling in 2014 that the Russian state should pay $50 billion US to the former shareholders of UCOS. That was a very, very significant award. And in 2014, the tribunal had ruled, and please don't think that I agree with these things, I know nothing about whether there was any graft or corruption behind the scenes. My judgment about these matters is confined to the legal implications, but the tribunal ruled in very strong language that the Russian government had manipulated the state legal system with the effect of bankrupting UCOS and causing enormous financial damage to the shareholders. And there were allegations of tax evasion, and the Russian authorities seized UCOS's assets. And then that tribunal judgment or decision was then overturned in the Russian Arbitration Court, because under the energy treaty, Russia had not made its decision to fully ratify the convention. And although Russia had signed the convention and had made public its decision not to make a party, what had really happened was that the tribunal had to decide the effect of Article 45 of the ECT, the Energy Treaty, because that said that if Russia doesn't ratify this treaty, in view of Article 45, Russia would only be bound by provisions of the treaty that are reconcilable with Russian law. Okay? So it's important to understand that the UCOS case and the ground upon which the arbitrator's decision was set aside related to the question whether the treaty bound Russia or not. And under Article 45, because there were provisions of the treaty which were not compatible with Russian law, then the questions that had been raised in that case were not arbitrable. In other words, they weren't legitimately the subject of arbitration. So although lots of nasty things were said about Russia in that particular case, it was not arbitrable. It was not validly subject to arbitration. And that's the real decision in UCOS. But in the meantime, all sorts of cases are being proceeded with against UCOS in other parts of the world. There have been proceedings trying to enforce the award in Sweden, in Holland. Where else did they go? I think they went to Dublin, they went to Paris, and particularly in France, very, very significant value Russian assets were seized. Ships and embassies and all sorts of things all over the world. But now the courts in Holland have specifically found that the arbitration should never have gone ahead in the first place. Okay, it hasn't been overturned on the merits. For all I know, the Russian state did do all these things against UCOS. For all I know, UCOS has got the case wrong. But now the question which is still alive in UCOS is very much the same as the one that we will look at in Maximov's case. What happens to an award which is set aside at the seat? Now, the French take an a-national view. They take the view that an award has no connection with any country's specific legal system. It's just up there in space, floating around. And in typical French fashion, they take the view that it just doesn't matter if that award is set aside at the seat. And they take that view if they are satisfied that the award does not offend French law. Okay? Now I'm taking this very slowly because there's all sorts of law, and we'll look at that in a moment. There's the procedural law, there's the substance, the choice of law clause in the contract. There is the law in any of the other countries where you seek to enforce the award. So as we'll see in Maximoff, where the important decision of the English Commercial Court upheld the award, the decision on the award by the Russian judge, whose judgment we'll look at later. So that's a little bit about UKOS. We'll come back to it, and a little bit about Maximoff, but what at the moment we're doing is looking at the building blocks of international arbitration, and they are to be found in the arbitral agreement. Okay, so the agreement between the parties, and this is the start of the whole thing, and we've been having arbitration since before the Middle Ages, but the agreement between the parties is not to litigate in the state or national courts, to apply a chosen law as the substantive law of the dispute, and that could be any law. It doesn't have to be connected with the international transaction. You might like New York law, and if you can convince the other party to agree to that, then in the arbitration clause it will state that New York law will be the choice of law. And you look at the rules under the New York law about breach of contract, about termination, repudiation, liquidated damages, and so on. So you'll get experts who come to the arbitration tribunal, and they will give evidence about what is the state of New York law. You might like, for example, and you might persuade the other contracting party not to have any national law system at all. You might want to come up with something like the choice of law clause will be one which has been worked out under the UNCITRAL, the United Nations commercial law, under the law of the UNCITRAL law about contracts. There are laws in Europe where there are evidence, or there is evidence of convergence. Say, for example, in the law of contract, there is now a kind of draft European transnational law of contract. If you wanted to, particularly because the content of that law is certain, you could agree that that's the law under which you will have the substantial dispute under the contract decided. But you've got to pick one law, and it's got to be recognisable, and it has to be discrete and specific so that someone knows exactly what's entailed when the arbitrators sit down to make their decision. It could be the law of the Congo, it could be any law the parties agree, provided it can be specifically identifiable. Now the seat, I've mentioned the seat, can't tell you how important the seat is. You have to have a seat, and by that I don't mean your bottom. I mean you've got to have a seat of law so that the procedural law can be identifiable. And good seats are those where the courts are arbitration friendly. You don't want to go to a dopey place, some small country in some far off part of the world that knows nothing about arbitration. Because it's under the law of the seat that will be determined the question whether the award can be annulled or not. That's in the first instance. And if you don't like any of those places, you can come and have the hearing in Moscow. But Moscow won't be the seat. Now, do you all get that? Because if you don't, we go off the rails straight away. You can have a seat in Sydney, but if you don't like Sydney for some strange reason, you can go to London and physically have the hearing in London. Okay? A friend of mine was asked to do an arbitration a couple of months ago in Lagos. Now, Lagos is a place, I hope we've got no Nigerians here, but it isn't a very nice place, and there is a lot of graft and corruption in Lagos. If you think Russian traffic is bad, it's nothing on Lagos. And the arbitration agreement said that the tribunal should be placed, not seated, but placed in Lagos. And the three arbitrators got together and said, there is no way we're going to that such and such effing place. And they went to Cape Town, and they had the hearing in Cape Town. But the arbitration continued to have Lagos as its seat. Okay, now we've mentioned the decision of the arbitral tribunal being final on the facts, and that, however, is subject to the tribunal having observed the rules of due process. And in almost every case, well, every case where the party concerned has selected a place where the model law applies, then you've got the model law requirements of due process, which are exactly the same as the New York Convention. So if you've got a good argument under the law of the seat that there has been a breach of due process, then you'll have the same and an equally strong argument later under the New York Convention when it comes for recognition and enforcement. Now, I mentioned arbitrability a little while ago, and there is a doctrine that you need to know about in relation to when it is that you can effectively challenge arbitrability. That is, whether or not the particular dispute can be arbitrated. You can't arbitrate, for example, family disputes. You can't arbitrate criminal disputes. Why? Because there's no contract with the state that if someone's charged with murder, you can wander off and arbitrate it. That would be nonsense. But I mentioned in UCOS that much later than the award had been delivered, a court said, hold on, under Article 45 of the Energy Treaty, this shouldn't have been arbitrated. And you might then ask, well, why wait till after the award was handed down? Because that's what's happened. The reason for that is that there is a doctrine called competence, or in German it's Kompetenz. Now what that means is that when one party seeks to initiate a dispute under an arbitration clause, if the other party contends that this is not an arbitral dispute, the arbitral tribunal has itself the power to rule on its own jurisdiction. Okay, so someone pops up in front of the arbitrators and says, look, nobody should be here because you, the tribunal, do not have jurisdiction. Now, jurisdiction means the authority to adjudicate. That means that someone's arguing that you do not have the authority to arbitrate because this dispute is not covered by the arbitration clause. In Australia, for example, you can't arbitrate insurance disputes. In other words, they're not arbitrable. Now, in this case, the arbitral tribunal is given express power to rule on its own jurisdiction. Now, that might seem funny. It might seem like as if it's Caesar appealing to Caesar. But it's not. It enables the arbitration to get underway without delay, because what we're supposed to be doing in these cases is getting ahead of the game by running the arbitration faster than you would under the general law. Now, there are three aspects of this comparative speed between arbitration and the courts. Now, if you start a case in the Supreme Court here in Moscow, you are competing with thousands of other companies and individuals who have also started proceedings in that court. And you've got to wait sometimes years. In India, you can wait 20 years and still not get your case on. A friend of mine in India who's a Maharaja has been fighting his brother in order to decide who is rightly the Maharaja of Jaipur, a beautiful state up in the north. And that case has been going for 25 years because they're waiting to get it on in the courts. So one of the reasons that you go to arbitration is because you get your court almost straight away. You're not waiting for one of the judges to work through 10,000 cases before he gets to yours. You pick your tribunal and you know that they don't have a lot of other cases at that stage, so you save months, if not years, right there and then. Now, do you all follow that? You're just jumping an enormous queue by saying, we'll have our own private court. We won't worry about these characters in the Supreme Court. We will agree that our case will be decided by, if you like, arbitrators, private judges. And we look them up on the net and we see whether they're any good or whether someone has said that this fella Collins is a fool, don't appoint him, and all of that kind of thing. But when you actually start the arbitration hearing and preparation, the difference in speed between that and the case in the Supreme Court, say Moscow, anywhere, starts to become smaller. The actual steps, we'll look at those shortly, by which you proceed through the arbitration, pleadings, statements of the parties, statements of the expert, the actual speed that you get through those steps is a lot closer to the court. Okay, so you've got to be very careful when someone tells you that arbitration is very much faster when you actually start. It's not. It should be faster, but nowhere near the difference between the starting time and getting to hear the arbitration. But the third time comparison is one between what happens after you get the award. Now, because the arbitration award is final, here in Russia, that would cut out, and it does in most countries, two separate levels of appeal. It means, and that's subject to the Yukos type case, but in the main, where the award has been done properly, in other words, proper reasons and so on, then you'll cut out two different levels of appeal, which could be 2 or 3 years. Okay, so you're saving years at the front end and years at the back end. But there will be some proceedings in some cases that we'll look at shortly. Now, just to set the scene for what it is that you can do under the New York Convention, just let me quickly tell you the 5 grounds. And these are in Article Roman 5. It's a beautifully short, concise treaty, the New York Convention. If the arbitration agreement is invalid, that is the first ground upon which recognition and enforcement will be refused. The second ground is that if due process has been violated. Now, has anyone got a shorthand definition of due process? Just anybody have a go. Well, it's nothing more or less than a fair and equal hearing to both parties, is it? Now, due process rights can be infringed or violated in many ways. And when you start your course, your professor should take you to an article that I took my students here the other night to look at. It's in the Journal of the no, it's not New York, it's London, the London Court of International Arbitration Journal. It's called Arbitration International, and the article is called Due Process Paranoia. It refers to arbitrators who are afraid to make decisions about the risk, about the efficient operation of the tribunal, because they think they may be in danger later of having the award set aside. In other words, they're timorous because they don't want to say, look, you've asked for 6 weeks for your first witness statement. He has said, no, you shouldn't have 6 weeks. You should have 3. And the arbitrator knows really deep in his heart that 3 should be enough, but he'll sort of think, oh, 5. Okay, due process paranoia. And that's a very common complaint in international arbitration, and the effect of it is, in large doses, to make arbitrations run longer than they should. So that's due process. The third ground under Article 5 of the New York Convention is an excess of powers or jurisdiction. And that's simply where the arbitrators start to decide some issue that is not covered by the arbitration clause. Okay, if it might be a claim for rectification, and for some reason that might not be covered by the arbitration clause. It might be a claim in tort, which is just a French word that means a civil wrong, or delict. It might be a delictual claim that for some reason might not be covered by the arbitration clause. And so that's why if you want to have arbitration as the court of one stop, final stop, you've got to make sure that those opening words that I read, just from this example, all disputes arising out of or in connection with the contract, you've got to make sure that draws in everything, okay? Now, as I said to students here the other night, I think one of the best standard arbitration clauses is the one from the Vienna International Arbitration Centre, which talks about all disputes arising out of or in connection with the present contract, its validity, they add that, formation, they add that, or termination, they add that. And as they are, as it were, tightening up the clause, they are making absolutely sure that they draw in all the disputes and there's no mistake made that some have been left outside the clause. Do you follow? Now, I don't mind if you ask questions at any time, because I know that sometimes I tend to think quickly and speak quickly, but just stop me if you don't get this. Because if you get what I'm talking tonight, you're going to go into the arbitration course here, streets ahead of those who haven't had occasion to think about it. So please don't think that I mind interrupting. The next point from the Article 5 of the New York Convention, this is a ground not to enforce an award, is if there's an irregularity in procedure. Now that's a little bit different to due process. An irregularity in procedure is really something which occurs when the tribunal does not follow what the parties have agreed in procedure. And the best example of that is where the tribunal doesn't follow the set of rules that you've agreed to. Now this is the new product by people in Belarus and Russia called the Prague rules. We'll come back to that later. But that's the fourth ground. The fifth ground under the New York Convention is the award is not binding or has been set aside. Okay, so that's a good trip through the arbitration clause and its critical significance. Now, it's appropriate now to look at the laws that you are going to have to be concerned with in this interesting area of the law that you're going to be studying at this university. Firstly, as we saw, there's the substantive law. The law that the parties have chosen will be used to regulate the dispute. So if it's a frustration case or if it's a force majeure case, you've done contracts, haven't you?
We do.
Yeah, you've got in Russian law the doctrine of force majeure, haven't you? It's a bit like frustration, but it's when something comes in and basically destroys the subject matter of the contract, or a typhoon causes the ship to sink, and there are rules in contract which assign the liability for the loss. Then there's the choice of the seat, right? Not the physical place, but that's your procedural law. Then other laws are the law of the place where you seek to enforce the award. It could be the seat, but it could be anywhere where the unsuccessful party, the respondent, has property, provided it's one of the 150 odd countries who have signed on to the New York Convention. So it's almost as if you've got to get your head around an international legal system where laws are being pulled in from a variety of places, and where when you're deciding these things in advance for your client, you've got to give advice to that client that enables the client to know with confidence that you've picked a good seat, that you've got the right choice of law, because if you stuff up, there can be big consequences. So it could be any one of the 150 countries who have ratified the New York Convention and where there is property. Now, this choice is extremely important, as we'll see with Mr. Maximoff, because there are different approaches in different countries to the question what to do with an award which has been set aside at the law of the seat. And if we look at what happened in Maximoff, let's just look at the way in which that bites. Now, Maximoff got an award from the ICAC here in Moscow. He got an award for 8.9 billion rubles. Okay. Now, the defendant, or the respondent, same thing, then sought to set the award aside here in Moscow. Okay, and Moscow was the seat. Now, Judge Shumalina, who's apparently a very competent judge, she set the award aside. No need tonight to worry about why. That'll no doubt be opened up to you in your course. We want to look at the consequences rather than the reasons for the consequence, just on this issue. Has anyone got a hot date at 7:30, or how long are we going for? What's the plan? Who told their mum they had to be home at 8:30, or 9 o'clock, or 8 o'clock? What's our plan?
Well,
So, go. Then Mr. Maximoff goes to the Federal Arbitrage Court, and that court dismisses the appeal. and there are some very interesting questions in here. How can I go about getting the judgments translated into English from Russia? I want to write something about this because there are some legal questions of great interest. The Court on Appeal actually found new reasons to set the award aside, but I'd be better off getting that done here in Moscow, wouldn't I? Get some translator here to do it, or do they provide an English translation somewhere?
Well, I don't think the court will provide the translation, but since this is a very famous case, there might be a translation somewhere on the internet.
Mm. Yeah, I haven't looked on the net for a translation, yeah, but that's a good idea.
Yeah.
Then there was another appeal. So Mr. Maximov is not doing terribly well. Judge Shumalina said that the award's to be set aside. Appeal from Judge Shumalina to the Federal Arbitrage Court. That appeal was dismissed, so Mr. Maximov is still on the wrong side of this case. And then the Supreme Court of Arbitrage in Russia also dismissed the appeal, and that left the award annulled. Okay, 3 very good Russian arbitrators, but the award was annulled. So then the interesting search for assets begins, and again the fascinating question is raised. What happens to an award which is set aside at the seat? Does it just become nothing? Or is it like the French view where it's just circling up there like Yuri Gagarin in space? And that's the key question. So if we look at France first, Mr. Maximov goes to France. Okay, now France take this international view. They want to detach the award from the seat. And they say, look, 3 good arbitrators have done a proper job here. They haven't stuffed up due process. They haven't offended any of the laws of France. And that question was alive because they made the application in France. Now, France held, the French court held, in favour of Maximov, that the award should be enforced. So there must have been some assets there. The award remained in existence. Okay? Now the theory behind that is a remarkably simple one. Because the parties had agreed that the award would be final. And unless there's something in the process that offends the laws of France as viewed by a French judge, then they don't care what Judge Shumalov said. Judge Shumalina, I'm terribly sorry, Judge Shumalina. Now, there were lots of comments made about Judge Shumalina's decision, and those comments were extremely critical. Going to look at them in a moment. And this is not me talking. This is an English judge talking, because I'm very careful to be courteous to the procedure here in Russia. I get sick of people in other parts of the world standing up and criticising other countries when very often there's much to criticise in that particular country, and Mr. Trump would be the very best example of that. So France, yep, there's an award there. Don't care what Mrs. Shumalina said. But then in Holland, Maximov also went to Holland. Why? Because Holland is party to the New York Convention. Now, the principle that applied in Holland is that an award annulled at the seat can only be enforced in Holland under exceptional circumstances. And that occurs when it would be a violation of Dutch public policy to give effect to the award. In this case, the Dutch courts held that there was insufficient evidence to show that Mr. Maximoff did not receive a fair hearing before Judge Shumalina. Now, just to cut out all the negatives, what the Dutch court said, they didn't have enough material, enough evidence before them to show that there was anything wrong with the hearing before Judge Shumalina. Okay? So, in that particular case, to give effect to the award would violate Dutch public policy. So you're left with Judge Shumalina's decision, annulling the award. Mr. Maximoff loses. Okay? Now, in England, the position is slightly different. This is what Mr. Justice Burton, B-U-R-T-O-N, Justice Burton said when an application was made to enforce the award in England. Maximoff sought to enforce, said the judge, to enforce the award on the ground that the Moscow Commercial Court's decisions were perverse. So that was the argument, that they were perverse, and must on this basis have been procured through bias. So the argument was that Judge Shumalina was biased, noting that there were aspects of the Russian court's conclusions that were perverse. So here's the court in England being asked to enforce the award and in effect take an approach contrary to Mrs. Shumalina's judgment. And even though the English judge said that there were perverse aspects of Judge Shumalina's judgment, even though one of the grounds relied upon, the non-disclosure ground, depended upon a conclusion of Judge Shumalina's that was unsupportable. Now this is strong language for one judge to be using about another judge. Even though that the public policy ground argued by Mr. Maximoff's counsel in London was hopeless. So here they're saying that this argument that was run before Judge Shumalina was so bad, it was hopeless, and she should never have based her decision on that. Mr. Justice Burton also said that he was very uncomfortable because two of the grounds given by Judge Shumalina for setting aside the award had not been mentioned during the hearing before that judge. Now that should be the kiss of death. But then he said that it was not enough, and this is counterintuitive, so you ought to just think about this carefully. It was not enough for the set-aside decision, that's Judge Shumalina's decision, to be wrong. Okay? Now Mr. Maximoff must be saying, gee whiz, I'm just about over the finish line here. Shumalina's decision has been described as hopeless. Another part of his judgment said that her conclusion was adventurous. Now when a common lawyer says adventurous, it means B-U-L-L-S-H-I-T. Okay, that's a very polite synonym. If I say that Vadim's argument is adventurous, that's just about saying it's absolute rubbish. And he had some evidence also before him that people here in Moscow thought that Judge Shumalina was pretty good. And then he said that he was unpersuaded that the set-aside decision was so extreme and perverse that they could only be ascribed to bias. The harshness of Judge Shumalina's award on the three, quote, distinguished ICAC Russian arbitrators was indicative of the court's distrust of arbitration. So this Maximoff case is extremely interesting from an intellectual and a cultural point of view. in the end, even though Judge Shumalina's decision was criticised very, very severely by the English judge, there's a kind of international comity where judges, almost like they're members of a trade union, not quite, but they want to have been seen to have tried to be respectful of the other judge's judgment. Okay, so Mr. Maximoff loses. And you saw the different approaches. In England, again, whether the Russian court's decisions were so extreme and so perverse as not to be open to a Russian court acting in good faith. So it's a very high standard, a very difficult standard to get over, to try to set aside in another country a decision of a judge in the law of the seat which sets aside the award. Okay. Now the New York Convention, I think we've said enough about that, but just remember that whatever happens in the lead up to the award and afterwards, out there at a kind of a brooding presence, you've got the big hurdle of the New York Convention. There are books being written about it. Albert Vandenberg's written the best book about it, but the great thing about the Maximoff case is it will teach you the ins and outs of the law right up to the New York Convention, and then you can look at how the New York Convention is applied in different countries. The French, les frogs, they are the most confident people in terms of reviewing an award. They think that the award ought to be set aside unless there's something so horrible associated with it that it must be set aside. Now let's go back to England for a moment. It's important when you look at the New York Convention that in England, just because a New York Convention ground has been established does not mean that the English courts will set it aside. And that's of great importance, because you will read and you will hear time and time over the importance of the New York Convention. But in England, just because a New York Convention ground for setting aside the award has been established, the English court will not automatically apply it. Okay, so you'll go to court with a good New York Convention argument up your sleeve, but the English judge will tell you that it is still a matter of discretion. Okay, and it's terribly important, you know, as law becomes more international, more transnational, more compressed, as particular principles start to merge from one country into another, it is very important that you understand the nature of discretion under the common law. Because discretionary decisions are also given some protection under the common law, provided I listen to the arguments of both sides on a discretionary argument, and provided I take their arguments into account, there's a very good chance that my discretionary judgment will be upheld. And that's something you need to understand about the common law. You want to ask? Yeah, go ahead, mate.
So what's the standard in determining whether to uphold the New York Convention argument or not? How does a judge determine whether to apply it or not?
Look, I think it's going to be down to a number of factors. One is his own inclination about whether or not the award is right. Now, you won't see anybody saying that, because that's not supposed to be the law. But when confronted with a statement by one of his cabinet ministers some time ago, Abraham Lincoln was told, look, that's final. And Abraham Lincoln famously said, look, nothing is final until it's right. Now that, of course, is exactly the opposite of what happens in international arbitration. You will see and you'll hear of awards that are not right. They don't look right and they're not right, but unless you can squeeze them into a denial of due process or one of the other grounds. Now don't forget, the grounds to set the award aside will be under the local law, in other words, the law of the Russian state, or the agreed substantive law, or the law of the place where you seek to enforce the judgment. Now it's time with that background to talk about the rules of arbitration. Now the rules of arbitration are prolifically published all over the world. Here are some friends of mine from Minsk and Moscow trying to set up a new set of rules. I don't like them and I've told them a million times, but they're still trying to bring them into being. I'll talk about them in a while, but you need to know that as well as all those sources of law that I've told you about, if the parties agree, let's take that arbitration clause again, if the parties agree that all disputes arising out of or in connection with the present contract shall be finally settled, and the bit I haven't yet read deliberately is under the rules of arbitration of the ICC, okay? Now, it might be the ICC, it might be the so-called Prague rules, it might be the rules of the SIAC, Singapore International Arbitration Centre, it might be the, let's see, the Korean Commercial Arbitration Board, the Hong Kong International Arbitration Centre, the Beijing Arbitration Centre. All these are specific arbitration centres, some of which I'm a member of the arbitrators panel. Mauritius has just set up a centre and they've set up a new set of rules. Those of you who heard about One Belt, One Road, have you been following the Chinese attempt to dominate the universe? Yeah. So here are trillions, mega trillions of rubles, but trillions of United States dollars that are going to be invested by the Chinese, starting in places like Myanmar, Thailand, Malaysia, Singapore, as you come down the One Belt, One Road, by sea and by land, ending up in Kenya. Massive, unbelievable amounts of money that you couldn't imagine what it would look like. It'd fill rooms, what they're doing. But they have set up their own arbitration court and their own set of rules. You can see them, pardon me, online. There's the London Court of International Arbitration. There's the Stockholm Chamber of Commerce. There are the Russian rules as well. Not the Prague rules, but the rules of the Russian Arbitration Association. So, and many of them have a significant number of points in common. But if you have agreed that your arbitration will be conducted under the ICC rules, then remember my 5 rules from the New York Convention if there's an irregularity in procedure. So if you mess things up and you don't follow the arbitral rules, if you've agreed to conduct your arbitration under those rules in that centre, then you're leaving yourself open to the award being set aside. And it's for that reason that in the International Court of Arbitration in Paris, where, as I said, I've been a member for some years, the arbitrators are bound to send their awards back to the ICC for what is called scrutiny Now, the ICC can't itself decide an arbitral dispute, but it is told that it must scrutinise the award to make sure that that award doesn't exhibit any errors which are likely to cause the award to be set aside. So the ICC tries to protect the award by scrutinising it and then writing back to the arbitrators and saying, now listen here, you quoted a section from the Russian commercial law, but you didn't quote section 99 that says that that earlier section only applies in certain limited circumstances, or whatever the fault might be. So it's the duty of the court to scrutinise the award to flush out errors that the arbitrators might have missed. So we've talked about competence. I need to just tell you, having said what I've said about the rules, the distinction between an ad hoc arbitration and an institutional arbitration is very simple. If your arbitration clause doesn't contain an agreement that it'll be conducted according to the ICC rules and administered by the ICC or some other institution, then that's an ad hoc arbitration. What do you do for rules then? Well, the parties and the tribunal have still got to, pardon me, work out what rules can apply. But an arbitration which is conducted under the ICC or any other institution's rules and administered by that institution is an institutional arbitration. Now, institutions are springing up all over the world. A lot of the time, unfortunately, it's for the wrong reason. It's because countries think that if they set up an international arbitration institution, they can make money getting people to come to that country to use their premises, stay in their hotels, give work to their lawyers, and so on. I don't think very much of that as a reason, but it seems to be put forward by a lot of people. Now, that's the end of the first part of the lecture. You just tell me exactly when you want me to stop, because I want to talk about the hearing for a few moments. Now, are any of you interested in knowing exactly what happens during a hearing? You remember I said two things, that an arbitration is the alternative to litigating in the state or national courts, number one, and that an arbitration is judicial in nature. I'm not just sitting here with a big palm tree over my head, just deciding however I feel. I've got to decide the case in accordance with the choice of law provision, okay? Now, does anyone just want to talk for a little while about what an arbitration consists of? Well, suppose we're in this room, I'm the chairman, one party appointed arbitrator here, one party appointed arbitrator here, counsel probably back a little bit away. We start with an opening address, just the same as in court. The respondent may want to open straight after the claimant opens. A lot of people get a bit cagey and they want to, not KGB, but cagey. They want to open their case after some of the evidence has been led, right? But then all of the parties and the arbitral tribunal will have in front of them witness statements in writing which set out the witness's evidence. Okay, so opening address may be by the respondent. Then first witness who's already made a statement comes in and is cross-examined. Now, cross-examination is not something that is terribly attractive to Russians. I've always thought that Russians should love cross-examination, because I do, because I think it's great fun to beat somebody up if they're not telling the truth. And when you mention cross-examination in Russia, sometimes you get a fairly dim expression from the Russians who say, well, what do you need that for? Well, the answer is not everybody tells the truth. Not everybody deliberately tells lies, but a lot of people, for reasons that not all of us can understand, deliberately, while trying to tell the truth, don't get it right. And in my system of law, we think that one of the good ways to uncover people who aren't telling the truth is to cross-examine them. So after that witness statement has been read, that witness will be cross-examined, and then that witness will be re-examined. Now, what does that mean, do you think? Re-examination.
Checking the facts.
Is it putting Humpty Dumpty back together again, or is it something else? Was it you that was did you start? Sorry?
Yeah.
I interrupted you. I didn't mean to. I'm sorry.
Maybe checking the facts of the case again. I don't know.
Well, the arbitrators don't like hearing something twice, and they don't like time being wasted. And so many arbitrators have got into their heads the idea that you've got to limit re-examination. Don't forget, this is the same witness who's already put on a statement, who has been cross-examined, and then counsel pops up and says, oh, I'd like to re-examine him. Now, there's a general principle, and that doesn't mean, oh, look, I want to go over it all again. So what do you think?
Well, I thought that re-examination, well, cross-examination is when an opposing counsel examines, like, a witness put forward by another party.
Yep.
And re-examination is when a counsel who put forward that witness re-examines him.
And so you'll say to the witness, now look, Mr. Tchaikovsky, you said you didn't remember this conversation that you were asked about in cross-examination. So you've got to repair that. And you know what happened. You as counsel know what happened. And you say, look, did anything happen on the day, on the morning before that meeting that had any effect on you? So I'm not leading the evidence from him because I can't lead my own witness, but did something happen before that meeting? Yes. I said, I had a car accident and I received fairly serious head injuries. Now what that does is it fairly explains something that he said in cross-examination, doesn't it? Here's a guy with head injuries, well, he doesn't remember the conversation. So instead of allowing his answers, I don't know or don't remember, to be made the subject of severe criticism against him, you have in re-examination given an explanation for him not being altogether well at the time that meeting happened, okay? But you can't use re-examination just to rehearse everything all over again. So after re-examination, which will be very short, the next witness comes to give evidence and so on. Now in those respects, it's just the same as a court case. Okay, the evidence is being led. There aren't so many technical objections to the evidence, and the tribunal has got total power, total control over procedure. It's not like the Russian Supreme Court or the Supreme Court of New South Wales or the Supreme Court of England and Wales, where there are lots of procedural rules. The arbitrator decides what those rules are going to be ad hoc as the hearing goes on. Righto, well that's probably enough. How long have we been going for?
1.5 hours.
1.5 hours, so it's time for some questions. And you can ask questions about anything. It doesn't have to be what I've been talking about. Just give me an indication of how many people are going to do international arbitration. We've already decided. Right, you've all heard me and decided not to. That's good. So are there any of you still making up your mind about it? Right. Okay, so let's have some questions. Yep, go ahead.
bit silly, but at the same time, I used to talk about the law of seed, and as I understood, the parties had the opportunity to choose any country they want, and the law of this country cannot be connected with the law of the contract or the party.
No, it can be. It can be. There are many cases where the seat is the same as the law chosen.
Yeah, I understood. I mean, I don't know if they want to choose the Paris as the law of seat, yes, but they don't have anything connected with Paris in their case.
Doesn't matter.
It doesn't matter.
No.
But at the same time, they agreed with the law of the seat, and they should understand the consequences.
Absolutely. They go to Paris because you've got a better chance of the award being enforced in Paris. So you avoid all those problems that Mr. Maximov had and so on.
So, yes, that's the thing I would like to ask you. So when Mr. Maximov, when he chose the law seat in Moscow,
He probably thought that was okay for him.
Because
he had
mistake of the party.
Yeah. Because he had 3 Russian arbitrators who were prominent, were all good people, and he won. I mean, he must have been feeling terrific when he won. Now, I hope from his point of view that because he succeeded in France, I hope that the respondent had substantial assets in France, because he's trying to recover, don't forget, 9.8 billion. So let's hope that the respondent's got a lot of money stashed away in France. And that story I don't think has been completed yet, because there are still appeals going on. Righto, what about cross-examination? You've seen television. There are a couple of good English shows that show cross-examination in its better light, more accurately. But what do you think of cross-examination? Because a lot of the next generation of you don't think it's as valuable as I do, or other people. So what do you think? What's your view? Some people say, oh no, it's all in the documents. What do we need to cross-examine anybody for? Why do you think that's wrong? What do you reckon?
Well, I think cross-examination is a pretty useful thing because...
Done properly.
Of course.
Yep.
Because, you know, by cross-examination sometimes we can see by some controversies in witness statements that he or she's lying.
Yeah.
While in documents, it's not always obvious. We may check documents 100 of times before submitting to an arbitration.
Well, very often a cross-examination is based upon some of the documents that you've seen. Let's take an example. Suppose that I want to distribute in Australia some very large, sophisticated dynamos that use heat to generate electricity, but these dynamos are turned so as to generate the electricity by hydroelectric power, by water. And I have a meeting in, let's say, suppose they're made in Germany, with the head of the German sales group that sells these sometimes they're half as big as this room, huge, big dynamos that, you know, the water comes charging into the power station and turns these massive dynamos, and you can generate electricity. There's lots of those sorts of programs here in Russia. And suppose the sales manager says to me, not in any document, look, these dynamos are the best on the market. We've never had any trouble with the operation of these dynamos with any of our customers anywhere in the world. Now, this hero has only been the sales manager for a year or so, and he doesn't know what the full history of these dynamos is around the world. And it turns out that his representation to me is wrong. But nevertheless, I rely on that representation. Now, in order to prove that representation, I've got to call some oral evidence, haven't I? Not in writing. And I had this argument with a Russian friend yesterday, and I said, if you're not calling fact witnesses in your cases, Boris, how do you get this evidence in? How do you get evidence of waiver or estoppel? And I'm still waiting for an answer, but in this representation case of mine, don't I have to go into evidence and put on a statement that sets out that conversation? It's not in writing, but I've relied upon it. So in my statement, I'll also say that I relied upon it. Now, it'll be my oath against his oath. That's one level at which this dispute will be decided. Someone might think that I'm a shifty, shady customer and they mightn't believe me, but they'll believe the other person. But suppose further that I've got a very good idea about business practices, and I know that there will be reports in writing from the sales manager to his boss. And then there'll be reports from his boss to the board of directors of that company. That's just the way people conduct their business. Now, in that case, the sales manager may say something along the lines in his written report, look, I had a discussion with Collinsa and I emphasised the excellent history that we've had with this dynamo, these dynamos when we've sold them elsewhere. So he's got that in his document. Now, we don't have that in our documentary bundle, if you like, and we've got to get it from the other side. And we do that in international arbitration by making what's called document requests. Now, what would happen in the event of that statement that I said being concluded or contained in the document would be something along the following lines. Now, it says, I emphasised to Mr. Collinsa the excellent performance that our dynamos have had over a long period. And the truth is that before this guy came to the company, there had been trouble with these dynamos in, let's say, Switzerland and Spain. Let's pick another country where there's a lot of hydroelectric power. Suppose we take the United States, Oregon, or Washington State, where there's water everywhere. So I say to him, I get these documents by order from the tribunal. I've got them here, and the sales manager gives evidence, right? So he says, I deny that I said that to Mr. Collinsa. I'm then going to cross-examine him. So I'll say something like, now, Mr. Tchaikovsky, is this the truth? You've told the tribunal that you did not tell Mr. Collinsa that there had never been any trouble with any of these dynamos anywhere in the world. And he can't say no to that because it's in his statement. And he's sworn to the truth of his statement. So I'll say, now, you realise that you've sworn to that evidence, Mr. Tchaikovsky? Yes. And you did so after giving very careful consideration to the issues in the case and your recollection of the meeting. Is that right? Yes, he'll say. He has to because it's in his statement. And I'll say, now, you, under oath, have told the arbitrators that you never said anything like that. Nothing even approaching it. No, I didn't. And then I've got, in my brief, his report. Okay? Now I'll hand the report to him and say, now, Mr. Tchaikovsky, I want you to have a look at that report, in particular page 2, paragraph 3, where you're telling your board what you said in effect to Mr. Collins. Now, you say to him, is that your report? Yes. All your own words? Yes. And may the arbitral tribunal take it that you gave very careful thought to getting that report exactly right. Yes. And may I take it that you are telling the arbitral tribunal now that everything that's in that report is correct? Yes. And I show him the statement where he says that he told Collins about the history of these dynamos. And I say, now 5 minutes ago in cross-examination, you denied that very statement, didn't you? Now he can't say, no, he didn't, because it's down on the transcript. And so what you've done, you've shown two things in this case. You've shown that the contemporaneous statement that he made in the report to the board of directors is contrary to his oral evidence, but more to the point, by going through it with him in that way, you've got him to tell lies under oath to the tribunal in the box. Because he said in the box, I never said it. And so then in your submissions, you've got an argument, you've got a submission. You can say, members of the tribunal, you remember Tchaikovsky. He's the man who denied making any statement like that. He's the man whose written statement to the board is contrary to the evidence in his statement. But more important than that, he showed you that he was prepared to lie face to face with you about the statement that he made to Collins. So you see, that's the extra layer of disbelief. You've got him to lie at the time, not just when he made his statement months ago, but you can say to the tribunal then, well, there you are. You can't believe anything this man says because he's able to look you in the face, as he did, and lie. So you should reject the whole of his evidence. Now that's an example of how, number one, oral evidence is tremendously important to prove your case. Number two, how proper document requests enable you, and you tender the document as well, even though it's the other side's, you tender it. Number three, it shows how you can get the truth out of the document itself. And number four, it shows how you can demonstrate the willingness of a witness to tell lies. So that's a short lesson in why I'm a great believer in cross-examination. Sometimes it doesn't work. But wherever you've got a statement made by your witness, which is in high contradiction to the witness of the other side, if you don't cross-examine, what's the tribunal going to do? You haven't challenged the other side's evidence, have you? And that's what the tribunal will say. Although Mr. Tchaikovsky's evidence in writing was quite different to Mr. Collins's in his statement, yet Mr. Collins's counsel chose not to cross-examine Tchaikovsky and did not put to him in cross-examination that his evidence was wrong. Okay? So, anything more that you want to do? You've had a good run through some important propositions. One of the other things I'll mention quickly, and I mean quickly, is that every month in the International Court of Arbitration in Paris, there are almost, on average, 4 challenges to the appointment of arbitrators based upon their lack of impartiality and their lack of independence. In the last 6 months, 4 books have been written in English on disqualification of arbitrators for conflict of interest violations. 4 books, they're all internationally available. So one of the sexy hot topics at the moment in this field is the question whether or not an arbitrator should be disqualified, and this is now the international test, because there exist circumstances which give rise to justifiable doubts as to his impartiality or independence. So you don't have to prove actual bias, okay? Prove circumstances which give rise to doubts as to his impartiality or independence. Don't have to prove actual bias. You don't have to prove that one of the archbishops of the Russian Orthodox Church saw the claimant giving 1 million rubles to one of the arbitrators. All you need to do is to show that there are circumstances which give rise to reasonable doubts. An obvious one would be if the claimant, managing director of the claimant, was the arbitrator's brother. Now obviously that's going to give rise to reasonable doubts, isn't it? Yet there may be no actual bias. Okay, 4 books published on that, and I'm sure that your lecturers will be spending a lot of time on that, so please bear that in mind. Any other questions? I'm not rushing off, I just want to know whether there's some questions and we'll deal with them.
Please.
So, if it's possible, I have 2 questions.
That's all right.
First of all, what is your opinion concerning the attractiveness of Russian arbitration courts for foreign company nowadays, taking into account Russian arbitration reform?
What's the colour of your speaker? Red, still red.
Yes.
And that's said with a lot of respect. Really, I love Russia, and I've been here a number of times, and I just love walking around the streets and just doing things and going to the ballet, and I absolutely love Russia and Russian history. So please don't think that I'm a cultural warrior. I'm not. Russia just has got a long way to go. But I think the important part of the answer is Russia is making fantastic steps forward. You know, the Russian Arbitration Centre has annual reports, it conducts conferences, and it's going. One of my fellow members of the International Court is the arbitration partner at Baker and McKenzie, Vladimir Kalevy. He's at conferences all over the world. Alexander Kropalski, he's from Minsk, he's very prominent internationally. More and more Russians are becoming prominent internationally, and there's a lot. I read in the CDR bulletin yesterday that there are lots of developments in arbitration in the west of this country, and I think there is rapid, very rapid development, and it won't be long before, you know, you'll be. Red's only an unofficial thing, it's not written down anywhere, but the big firms have their own little, you know, and if I was a client of an English firm, they would tell me not to come here, don't be seated in Moscow. And I think I've got to be honest with you about that, because you're the guys that can change that. You know, it's, but there are still massive arbitrations in which, you know, companies like Gazprom and those sort of companies are involved in. So what was the second part of the question?
So it will be another question concerning what are the most interesting spheres in arbitration nowadays for you? Maybe some hot issues or unresolved issues in arbitration?
I think Maximov's case has got a lot of interest for me. I'd like to see just what the Russian judge said, Shumilina, and just see whether or not that judgment that she wrote clashes with my own intellectual appreciation. So awards set aside at the seat is still a big hot international topic. Yeah. Okay, anybody else? Don't, I'm not going to be embarrassed if you all don't jump up and down. I just want to give you the chance. It's like due process. It doesn't mean anything. It just means that you're given the chance to do something. Nothing else? Way you go, good. The best questions sometimes always come from the back. They're the ones you've got to worry about. And you think, what's she been doing down there all this time?
Carefully listening. Well, I wanted to ask about the arbitration administered by the center, and whether it necessarily coincides with the physical placement of the arbitration. And say, can we have an arbitration administered by the ICC, but governed by Russian or English procedural rules?
The answer is yes, you can. Just because you've picked ICC rules doesn't mean you have to have a seat in the ICC, and I've looked at hundreds and hundreds of ICC awards, and many of them, you know, from places like Bulgaria and Romania, and they're not seated in France. They're just seated wherever. Who's got the best bargaining power? Any more questions?
Well, since we are limited in time, I suggest people who do have questions ask them personally.
Yep.
And we would like to thank you, Mr. Collins, for this lecture.